point of order, Your Honor.
Mr. Russo, because Judge Sleet asked me, how do you pronounce, is it Forget or Forget?
Forget or forget?
I was just asking trial counsel the same question. We believe it's Forget.
Forget. Oh, Forget.
The French.
Okay.
Mr. Wilson?
Okay.
Forget?
Under the impression it's
What I call in the trial.
Forget. Yes, Mr. Russo.
As a point of order, Your Honor,
Yes, sir.
I don't know if it's important for the visual record, but the nameplates for Judge Morris and Judge Sleet have been reversed.
Oh.
And that may be important for those watching.
Okay, let me have it. We'll do it right now. We'll take care of it right
This will be a
now.
first.
Thank you, Mr. Russo.
I'm honored to be Robert Morris. Okay.
All right. Okay, whenever you're ready, would you like to save some time for a rebuttal?
I would, Your Honor, 5 minutes. Anthony Russo for the defendant, Marion Fritz, who is the widow of David Fritz, who was the driver in this motor vehicle accident, and his estate. And I would like to reserve 5 minutes as my time for rebuttal. I'll get right to the point. With the court's permission, at the end of the defendant's case, after we rested, the plaintiff's trial counsel led the trial judge into making a pair of interrelated serious errors. One was to inject a new theory of recovery against my client, the indivisible injury rule under Gross versus Lyons, and the procedural mechanism by which that was applied, which was the application of Jury Instruction Rule 501.5b, the Gross versus Lyons instruction. That's a very harsh rule, and for the defendant, and that's Judge Pariente's description of the rule in her Gross versus Lyons decision from the 4th District.
Are you arguing that that was the first time that 501.5b was raised at the close of all the evidence?
I believe it was, Your Honor.
Because I looked at the record and Forget filed a list of jury instructions including 501.5b.
Yes, he did.
In his notice May 16, 2013.
May 16th at 3:51 p.m.
Pre-trial. Still before.
No. The jury charge conference was held May 15th, Your Honor.
Okay, so this was
We
filed.
rested on the afternoon of May 16th.
Okay.
And while Ms. Hanson, the trial counsel, was at trial, that was filed.
Okay.
And I would like to actually go to that point that you're raising, Your Honor, because the essence of the problem here is that the theory of this new theory of recovery was never argued. It was never raised in the pleadings. We know that. It was not tried by consent. And the jury instruction, the procedural mechanism by which it was implemented, was not supported by the evidence. It was not required to resolve the issues that were raised by the parties, and it was used to deadly effect by a very skilled plaintiff's counsel at the trial. And I'd like to walk through a few portions of the trial on behalf of my client to show that's the case, that this issue should not have been injected and that jury instruction should not have been given.
Well, the difficulty with this issue and the testimony in this case is the question centered around were his injuries caused by the automobile accident, were they as a result of a degenerative condition, or were they caused by this accident where he was lifting this 150-pound trailer? So it would seem to me that given the testimony in this case and those three possible causes, this is not terribly an illogical thing to argue in closing argument, nor is it an outrageous jury instruction to give, because they sort of all bled together as the experts testified. So help me with that.
Yes, sir. I do disagree that they blend together, so let me explain what the plaintiff's position was, starting with the opening statement. If you go to their opening statement at page 36, the plaintiff's position from day one was the motor vehicle accident was the cause of all the injuries. He never complained of back pain before. The motor vehicle caused the accident. The workplace accident 5 months later caused what he called a flare-up. This is transcript 35, of which I mean a temporary aggravation of the injuries that were caused by the motor vehicle accident. The plaintiff's trial counsel said in opening, Dr. Delgado. Now, he's an important person because he's the workers' comp doctor who looked at MRIs of Mr. Forget from before the workplace accident and after the workplace accident, and he said there's no difference. And that's what the plaintiff said in opening. The other doctors, Dr. Delgado will testify, who treated him, there was no change in the MRIs. It remained the same. So the plaintiff's theory was it's all on the motor vehicle accident. Now the defense theory, as you'll be able to tell from defense counsel's opening statement at record 79, summarized it saying the plaintiff had pre-existing degenerative changes in his neck and back that were not affected by the accident. She's saying there will be testimony presented to prove this. 2, that he had no restrictions on his activities as a result of the auto accident, including working. 3, that he doesn't require any further treatment as a result of the auto accident. And 4, he does not have a permanent injury as a result of the motor vehicle accident. That was our theory. It didn't touch the workplace accident. Now, with page 77, she mentions it because it's going to be talked about. She says, you'll hear varying accounts of the type of injury he had after lifting or trying to lift that 150-pound cement mixer. He had some treatment with a neurosurgeon, Dr. Delgado. He had another lumbar MRI. It showed no change from the one before. So we're at opening statements. We do not have a Gross versus Lyons case. We do not have the plaintiff saying, hey, this workplace accident caused it all. That did not happen. This is not a Gross versus Lyons case.
Did the defense move to reopen the case to address apportionment when 501.5B came up?
At the close of evidence on May 16th, defense rested. The first thing the plaintiff did was say, I want to add the 501B5 instruction. We objected. There was argument. And the judge said it's coming in.
Okay, but there's no motion to reopen?
No, there was no motion to reopen. But we had a jury ready to go with the case.
But did the defendant present evidence or testimony that all of the plaintiff's injuries and present complaints were caused by the work-related injury?
The plaintiff or the defendant?
The defense.
No.
Okay. Because here's my concern. I read the record. See, the plaintiff says this is a high-speed rear-end accident. The defense says it's a low-impact rear-ender. Plaintiff says permanent injuries. Defense says degenerative injuries. Plaintiff says pain while in the back while at work after the work accident. Defense says no complaints, no restrictions, full duty after the motor vehicle accident. On cross, the defense seeks to introduce the JCC order, but that's not allowed. But they're allowed to cross on the substance of the order, which goes into evidence. The jury is informed of claimant continues to suffer from pain and disability regarding the work-related accident. Evidence reflects he returned to full duty after the motor vehicle accident. And further on cross, the defendant says, after the May 20 work comp accident, it did injure me, but it was only a percentage of why I did not return to work. So here we have the plaintiff saying it did cause some problems, but it was a percentage. He doesn't quantify it.
Right.
But he says, yeah, this contributed to it. Well, the defense is saying it's either all the work comp accident or chronic, because you're saying it's not the motor vehicle accident. Plaintiff is saying it's all motor vehicle accident. Here we have a jury of citizens who are trying to decide how this occurred, and you're telling them that 501.5B should not have been given to give them guidance.
2 points on that, Your Honor. Number one, on the cross-examination was impeachment. It was not, that information was not added for the purpose to prove the truth of the matter.
The jury doesn't know the difference?
Well, Judge, the direct examination of Mr. Forget, there was 20 pages spent on the workplace accident. And Mr. Forget was asked on a diagram, if you read it, as you've read his description, it says, after the motor vehicle accident, I was injured, and I was down here on my ability level. And after the workplace accident, I went down, and then I came a little bit back up. It got better.
That was the
and
timeline.
Yes, the timeline. And then it got to the point I never got completely better. The cross-examination was to impeach Mr. Forget, and that was our right to show that he was telling different stories to different tribunals. So, because Mr. Forget went to the workers' comp judge, and the workers' comp judge wrote up an order that summarized the testimony that Mr. Forget gave there, and Mr. Forget said to the workers' comp judge, before this workplace accident, I could work. After the workplace accident, I could not work. And Dr. Delgado, so that's what we brought out, to show that he was telling different stories from one tribunal to another. Eventually, on redirect, he was rehabilitated by plaintiff's counsel, who came up and said, Mr. Forget, did you settle that workplace accident workers' comp claim? And he said, yes, I did. How much? $15,000. Why'd you take so little? Because Dr. Delgado's MRI showed me that my back had not been injured in the workplace accident. So even up to that point, we have not put any of this, we, the defense, are not saying that the workplace accident caused his injuries. We said just the opposite. In fact, Your Honor, our next to last witness was Dr. Delgado, and we got him on the stand in our case in chief and said, Dr. Delgado, did you see any problems from the workplace? Well, we didn't say that. We asked him about the MRI, and he said, I saw no change. I cleared him to go back to work without restrictions. That's our evidence. That's not us saying the workplace accident caused this injury. We're saying the workplace accident, that was the culmination of our impeachment.
Yeah, but the judge inquired of defense counsel during the charge conference.
Right.
If the defendant is going to argue the plaintiff's injuries were caused by the second accident, meaning the work accident, this instruction's coming in.
Right.
And to her credit, the defense attorney said, well, Judge, I can't make that commitment, then I'm not going to say that.
Correct.
So.
And in that colloquy, there's two parts of that colloquy. First of all, well, let me address your point directly. That's not the standard for giving the gross versus lines instruction. The standard for giving the gross lines instruction is when the defendant says, this accident, this injury that he's claiming was caused by somebody else's negligence or some other condition. It's not the defendant's fault. That's the standard, not whether we ask, were you injured, or say that the plaintiff testified he was injured in the workplace accident.
Well, then what evidence did the defendant adduce at trial to show that the work comp accident was divisible?
None, because it had not been pled, it wasn't our argument, and if the gross versus lines instruction is to be given, it has to be based on evidence from the medical experts of the plaintiff saying, hey, my fellow got injured in two accidents, and I, the medical expert for the plaintiff, cannot apportion between the two. But I have tried and I cannot do it.
Gross says what is required of the plaintiff is to do everything reasonably expected of him to segregate the damages as between the two cases.
The plaintiff.
But it doesn't set a standard. It doesn't require expert testimony or anything. So when that timeline came up about how have these two incidents affected your physical condition, he was asked about that. It went up, it went down, and then on cross-examination, he simply said, yeah, the work comp accident caused a percentage of my present pain and complaints. So how is that not proving that it's indivisible?
If it was divisible, Your Honor, it was the plaintiff's burden under gross versus lines to do everything they could possibly do to apportion it. And not one of their medical experts addressed, may have addressed it, but tried to apportion. That was their obligation to do it. Remember, the gross versus lines instruction is evil for the defendant because it makes my client liable for somebody else's negligence. And that's why it's a harsh rule. The burden of proving causation is on the plaintiff. This rule relaxes that evidentiary requirement according to the language of gross versus lines whenever there is evidence adduced by the plaintiff that the injury is indivisible. They didn't put on any such evidence, and we weren't claiming that the workplace accident caused the injury. And this is where the trial judge, in the heat of the moment, the defense has just rested, the jury's waiting to get the case, the instructions are about to be given, gross versus lines is put down in front of her. She's already rejected. The other point I want to make is, plaintiff got up and said, plaintiff's counsel got up and trial counsel got up and said, their whole theory, this is after we rest, they're asking for the 501b5 instruction. Ms. Hansen's whole story is that his current condition, he stopped working because of the workplace accident. She is asserting the reason he is not working is because of the May 20th incident. That's their position. That's what they've been saying from the minute they started cross-examining Mr. Forget. That's not true. That is not true, and it's repeated in the appellate brief, in the answer brief throughout the statement of case and facts. And that's a misapprehension of what happened at trial. We did not say the workplace accident caused his injury. We put on Dr. Delgado, who said he was cleared to work after the workplace injury. Even the judge saw that that was not right. The judge said, no, I think her story is this is more malingering. That's what I was telling you, Judge Sleet. We were impeaching this man by showing he was saying inconsistent things to workers' comp and to the jury. And Ms. Hansen says, yes, right. And the court said, that's what I picked up. So then plaintiff's counsel goes to Plan B, which is to throw down the Stewart or the Gross versus Lyons case in front of her. The judge has got everything ready to go. She looks at Head Note 5 of the 4th DCA Gross versus Lyons decision and asks the question that you've mentioned, Judge. Hey, Ms. Hansen, are you going to say anything about the workplace accident? And she said, well, I might, Judge. Well, yeah, sure. There was evidence adduced, 20 pages worth on direct examination by the plaintiff about the workplace accident. But we weren't saying the workplace accident caused the injury.
Well, I'm curious about something else. I'm sorry.
You're starting into your rebuttal time, but it's entirely up to you. If you want to
I'd like
stop
to
right now.
answer Judge Sleet's question.
All right, and I'll give you time for
The
that.
defense counsel introduced evidence of a work comp settlement. On redirect, plaintiff's counsel inquires further about that. Why did you settle for such a small amount? And this appears to be an effort to diminish the impact of the work accident on his present complaints and injuries. And he testified, Mr. Forget, I found out there was no further damage to my spine from the work comp. Is that not an effort to try to show to the jury that this work comp accident is not the cause of his injuries? But it also seems to further muddy the water, too.
Further to what?
Muddy the water for the jury.
Muddied waters are why courts, cases come to appellate courts. But I can say what is crystal clear is we never blamed that injury on the workplace accident, and it was never our argument, Your Honor. And that's when you give the Gross versus Lyons instruction. And I'll discuss the harm to my client on rebuttal, if I may, Your Honor.
Okay. Thank you, Mr. Russo. Okay. All right.
Good morning. May it please the court. Kristen Norris here with Stuart Markman. We represent Mr. Neil Forget, and we're from Kynes, Markman, and Fellman. There's a single issue in this case, and it's whether the trial court abused its discretion in giving this standard jury instruction on subsequent injury. And the jury instruction in this case was not an abuse of discretion because there was specific evidence presented by the defense in argument that Mr. Forget's injuries may not have been caused by this crash, but instead were caused by the subsequent work injury. Once the defense injected that theme of a subsequent injury defense into the trial, then the subsequent injury instruction was required under Gross versus Lyons. It was supported by the evidence. It was supported by the law. Now, I want to start right away with this idea that the defense really wasn't arguing that the work accident caused anything. And it's true that they hedged their bets on this. Their expert said, oh, he's just not injured at all. But the defense attorney consistently tried to bring up the work accident, tried to bring in evidence about the workers' compensation case. And again, as Judge Sleet noted, in closing argument, or at the time that this jury instruction was discussed, the trial judge said, are you going to argue the workplace injury in your closing argument and suggest that that caused some damage or caused some or all of his damages? And defense counsel candidly admitted, I'm not going to argue that, I'm not going to say that.
Let's play devil's advocate. What if at that colloquy, defense counsel said, no, Judge, I am not going to say that? Would have been error for the court to have given that instruction?
I think that's an interesting question. I mean, if she really was willing to stay entirely away from the work accident, could there have been, some explanation made to the jury at that point that that's not an issue? maybe it would have been okay to not give it at that point. And the judge certainly gave him the out. If you don't argue, I'm going to reconsider whether or not this instruction should be given. But if you're going to argue it, I have to give it.
So I guess my follow-up question, so it's your position that there was evidence presented to the jury that mandated the giving of that instruction?
Yes.
So the only way that it could have been relieved if you have counsel saying that's not an issue, we're not going to be argue that, and for it to come off the table.
Yes, I mean, at that point, it had been on the table throughout the trial. I mean, if you look through the record in this case, there's a lot of evidence and a lot of focus on this work injury. And, maybe the defense never said outright, maybe defense counsel never specifically said this work injury caused all his problems. But if you read the closing argument, it's he was working, he was fine. The only time he had to go home and not work was after the work incident.
And
so it certainly was the impression that they were leaving is, if you're going to blame this on anybody, blame it on the work incident.
And what's interesting, we don't know to this day what the jury's verdict led to. Was it from the car accident or from the work? We don't know that. And there was no specific delineation given to the jury as to what do they believe it was related to the car accident or what portion. We don't know that. It was just one big lump. Is that correct?
Right. Neither party asked for any kind of special interrogatory form to try to figure this out.
For all that we know, maybe that whole award, maybe the jury discounted the work accident and maybe they attributed it all to the auto accident. Do we know?
I would think that that's probably what they did, given that the evidence in the case was that there was, a very serious accident, high-speed collision. Mr. Forget knocked his head against the back of his truck cab enough to break the window, and that there was MRIs and things done right after that accident to show what those injuries were. There was this work incident, and then there were subsequent MRIs. So there was, as Judge Morris pointed out, there's this whole range of possibilities for the jury once you bring in the subsequent injury. Yes, it was Mr. Forget's position that the crash caused the damages he was requesting. He had actually separated out any of the medical bills that were incurred right after that work injury. That's his position at trial. There's nothing that says he has to hedge his position and then try to also prove an indivisible injury. There's no requirement like that in the case law.
Other than separating out the medical bills related to the two accidents, what did the plaintiff do to segregate the damages or try to segregate the damages between the two cases as set forth in Gross?
Right. Well, the plaintiff's burden, and there was a little bit of discussion by Mr. Russo on this, the plaintiff's burden is to prove causation, okay? And then there's a whole number of things that can happen. The plaintiff's burden is to prove causation that this crash caused his injuries. And so that's the evidence that Mr. Forget presented. Then there was obviously evidence that he had this work incident, and it was only after that he stopped working. So his evidence was pointed to, and his experts testified, it was the work injury, and after the subsequent, it was the car crash, and after the subsequent work injury, there was no significant change. This was all caused by them. There's no case that says a plaintiff has to be the one to then try to apportion the damages or have an expert say, well, we tried to apportion and they couldn't. The evidence in this case was basically, if the work injury did anything, it was, at least on the MRI, showing exactly the same injury. So the evidence was there to support the instruction. Am I not understanding the question, or?
So the fact that there's no change, the evidence showed that there was no change after the work comp accident, it's indivisible.
It would either, I think as Judge Morris pointed out, it either means it's a new injury that's indivisible, there was no new injury. These are all the things that are presented to the jury. And what the Gross versus Lyons instruction, if you read it, is actually a very balanced instruction. It says, don't award damages that are clearly attributable to the subsequent injury. But if you can't tell, then you have to award the amount of the damages.
I'm trying to figure out why, if the parties initially agreed to the intervening cause instruction and the aggravation instruction, why didn't they agree or submit 501.5B early on? It seems like a perfect case for it.
Yes, and the jury instructions, I think, the 40112 actually says.
It seems to me you put that in your packet pre-trial.
Right. It was not in the packet pre-trial. And the jury instructions change. In fact, under the rules of procedure and the pretrial order in this case, anybody couldn't request an instruction up and until the close of evidence. And so perhaps it wasn't anticipated that this was going to be as much of an issue as it turned out to be at trial. I mean, you have to remember both parties were taking the extreme position, and then there was the middle position. So what the evidence would show wasn't going to be clear until the close of evidence. But even then, I mean, even if there's, I mean, the defense's defense was subsequent injury. And this is a standard jury instruction that's been in the packet of jury instructions now for over a decade. If you're going to mount a subsequent injury defense, then a seasoned defense counsel should know themselves, both sides had to submit proposed jury instructions, that, wow, this instruction might apply. So it's there, it's been a long settled law. In addition, it was timely requested under the rules in the pretrial order. And then, again, the defense was given an out. The judge said, if you're not going to argue this, let me know before I rule on this instruction. And they specifically stated that they were going to argue it. And they specifically had an argument to try to address the indivisible injury rule. So there really could not have been a surprise given the long-standing nature of this rule, the procedures that were employed, and then the final out given to the defense. The jury instruction was supported by the evidence. That's what's required to get a standard jury instruction. There's a presumption that standard jury instructions are proper. There's certainly no showing that this would have misled the jury. It's a proper statement of the law, and there was no abuse of discretion. We'd ask the court to affirm the judgment. Thank you.
Thank you. Mr. Russo?
Russo, for my benefit, help me with this scenario.
Yes, sir.
On a case like this where we have these two incidents that all the parties go into, they fully discovered these two incidents, they certainly would know that this type of issue is going to be in play. And your position is that it wasn't pled, it wasn't argued, it wasn't advanced at all during
Correct.
the course of the trial, and it came up for a surprise for the first time in closing argument. So is that simply the issue for you? There was no heads up on it? And at the same time, I'll ask the question, how could there not be, given the facts of this case?
The surprise was that they would inject the indivisible injury rule into it. That was never in play. In the Gross versus Lyons instruction, because this is not, Your Honor, a perfect Gross versus Lyons case, there was the heads up. I mean, we knew about it, but it wasn't, nobody was arguing that the workplace accident was a cause of the man's injuries. We were saying he was not injured. We put on Dr. Delgado said cleared him to go back to work after the workplace accident.
Well, certainly wouldn't any lawyer who participated in this case anticipate that a jury would go back and struggle with this if they were not properly instructed about these two incidents and how they played in this whole picture?
It was not necessary for our case. If the plaintiff was concerned that the jury was going to be confused by it, it was their obligation under the charges to get the right charges in place and make the argument and give the defense a heads up that this was in play. But as I've shown from the opening statements, we did not put it in play. From the way we did in the plaintiff's case in chief, we did not put the injury on the workplace accident. In our case in chief, we did not put the injury on the workplace accident. And in our closing statements, which is the only thing I didn't get to, after we rested, they say there was, they raised the indivisible injury rule. The judge agrees to give the instruction, and then we are forced to address it. And what Ms. Hansen did was say, in accordance with what she argued in opening statement, this man suffered a non-permanent injury from the motor vehicle accident that did not aggravate or activate a prior condition, and he does not require future medical care. But if you're going to apportion, give him everything up to the workplace accident, which is $15,000, because he missed 4 days of work from the motor vehicle accident, and he had that much bills, medical bills, up to the date of the workplace accident. That's how we addressed it. We did not say all his injuries are are caused by the workplace
And how about,
accident.
Mr. Russo, Ms. Norse's statement that counsel was given an out at that time?
That is not an out, because what the judge asked was, are you going to, well, she said at 11:10, she asked Ms. Hanson, if you're going to argue the plaintiff's injuries are caused by the second accident, this instruction comes in. I might make that argument, Judge, and I'm not going to represent to the court that I'm not. Well, then this is coming in. There was evidence adduced in the plaintiff's case in chief. And remember, the plaintiff opened the door in their opening to the workplace accident. They opened the door in their direct examination of Mr. Forget about this. Our response to it was, that accident did not cause you a permanent injury. You were lying, or you were not being truthful with either the judge or the jury because you're telling different stories. Ms. Hanson, on the spot, knew that that evidence was in by virtue of what the plaintiff had said, and couldn't hamstring herself by telling the judge, I can't say that, I'm not going to argue it. But she did not argue it. What she argued was, as I just mentioned, what was in accordance with what she said in the opening statement, but if you must apportion, give him the $15,000. This is not...
And I'm going to give you one more minute, Mr. Russo, because we've asked a little bit of your time in rebuttal. But go ahead and take one more minute to wrap it up.
The closing argument that was used, it is not a perfect Gross versus Lyons case. Gross versus Lyons, the plaintiff's treating physician said, I cannot apportion my patient's injuries between the two accidents. And an instruction was given in that case, jury, you may not award damages for injuries not caused by the plaintiff. And that's not what happened here. That's not what we argued. I urge the court to read the closing arguments where Mr. Carter, the skillful trial lawyer, effectively used that argument to ram home the fact that the argument that it was our burden to apportion injuries. They didn't do it when Dr. Greenberg was on the stand. They can't come in here and ask you to do it on no evidence. So follow the law as the judge told you. It was devastating, and that's the way the case ended. And they came back with $1 million verdict for a man who lost 4 days of work and went back to work full time at his job on heavy labor. And that's a manifest injustice, and we ask the court to reverse.
Okay. Thank you, Mr. Russo.